I want to welcome you to today's Judicial Forum. The forum is being hosted by the John Locke Foundation and the Triangle chapter of the Federalist Society. I want to thank you for taking time from your busy schedules to join us today. The forum today is going to feature candidates vying for the judicial opening that will be open because Judge Wynn now serves on the Fourth Circuit. So the opening is on the North Carolina Court of Appeals. My name is Darren Bax. I'm the Director of Legal and Regulatory Studies at the John Locke Foundation, and I'll be moderating today's event.
I am Wesley Casteen, and I would like to thank the John Locke Foundation and the Federalist Society for the opportunity to be here today. This is a welcomed opportunity to get our message out and to provide a little bit more information about ourselves, which is not readily available from what's available to the general public. And people that take the opportunity to come here today are people that we respect and admire for being here. The 13 candidates that are part of the race for the Wynn seat, 7 of us are here today. Often the question becomes, how to pick out one of the 7, or how to pick out, in this case, 3 out of the 13. In this race, there are 10 men, 3 women. Geographically, there are 7 centered around the Triangle area, 4 around the Triad, and that leaves Judge McCullough and myself hugging the coast in Wilmington and Atlantic Beach, respectively. Of the candidates, there are 6 Democrats, 4 Republicans, 3 of us are unaffiliated. And as for myself, the biggest distinction is that in addition to being an attorney, I am also a certified public accountant and have been since 1989. My early career was in public accounting. I worked to get certified before going back to law school, returned to law school at Campbell, having received my undergrad at Wake Forest. After getting out of Campbell, began a general practice of law, which I maintained in the eastern part of North Carolina for a number of years. And more recently, my practice has been concentrated in the areas of commercial and business litigation, transactional work, taxation, tax defense, and civil litigation. Most recently, in fact, in the last couple months, I've received my Master of Laws degree in taxation from the University of Alabama, a 2-year project that I was happy to finish, proud to have completed. And again, I believe that's one of the areas that draws a distinction between myself and the other 12 candidates. I believe I bring a skill set that is necessary and appropriate to the court, and I'd like to have your vote and consider me for the Court of Appeals in this seat.
Okay, thank you. What problems do you most often see in appellate cases that you believe were wrongly decided? Other than Dred Scott, what would be an example of an appellate decision, state or federal, that was particularly bad?
And I thought we weren't talking about specific cases. The biggest issue, it's often said in law school that tough cases or close cases make bad law. And unfortunately, a lot of the cases that are in front of particularly the Supreme Court these days are cases where there are very strong positions on either side of the argument. And the case comes down to how to draw a fine line between those distinctions. And unfortunately, it's difficult to draw that fine line. In North Carolina, as far as cases that created some problem that needed to be corrected, I believe there was a line of cases back some years ago following the Supreme Court case in Viar, in which the Court of Appeals took license to dismiss out of hand a number of cases for technical violations of the appellate rules. That resulted in some fairly meritorious appeals that were dismissed and never heard. The Supreme Court came back in a case that I handled, Walsh v. Wrightsville Beach, and the companion case of State v. Hart, and the Supreme Court laid down some more definitive guidelines indicating that where there is a technical rules violation within the appellate process, it's more appropriate to consider sanctions rather than dismissing the case. And I think that was a rather significant position, and it also led to the elimination of assignments of error in the appellate courts of North Carolina, and I believe that was an appropriate decision as well, to allow the briefs to be heard on their merits, to have the attorneys prepare arguments based upon the issues that are presented in the briefs, and I believe that follows the federal procedure, and I believe it's an appropriate change here in North Carolina.
Let me follow up with what judge do you believe has been the most influential judge in American history? Or if you prefer, what judge has been most influential to you? You may qualify your answer that you do not agree with every decision the judge has made.
Well, I believe the current justices on the Supreme Court are hearing some cases today and over the last several years that are going to have a great bearing. Judge Roberts, I believe, is an appropriate role model for a lot of jurists. He has the academic and intellectual credentials to be a good jurist. He describes himself sometimes as an umpire calling balls and strikes, having umpired baseball and softball for a number of years. I don't know that that's an appropriate analogy, or at least one that's not well understood, because even there it's not always just calling balls and strikes. There's an amount of deference to the game, there's an amount of deference to the system that has to be understood when making decisions of the court and rendering decisions. And I believe it's always something more than balls and strikes. We have to look at the basis behind it, the parties behind it, the law, the reasoning, and be able to defend the decisions. Yes, precedence plays a role, but bad precedence is something that needs to be reviewed, and even if the Court of Appeals is bound by that precedent, I think it's appropriate to recommend a change to a higher court or to the legislature, not just to simply sit back and accept a bad decision where it may apply.
Thank you very much.